Today, the tech giants behind some of the most popular social media apps are headed to trial. This case is the first of thousands of lawsuits that claim platforms like Meta, Snap, TikTok, and YouTube knowingly created harmful products.
At issue whether these companies are responsible for the mental and emotional harm that their platforms cause users, especially teenagers. Jury selection is underway right now, and the verdict in this trial could set an important precedent for how these apps are allowed to operate. NBC News legal analyst Misty Maris joins us now.
Misty, it's interesting because it sounds like the strategy, at least legally, that they are deploying against these big tech companies is similar to the tobacco strategy they used back in the 90s. Would that strategy, in your opinion, be successful here?
Well, it remains to be seen because this case is the first of its kind, but it's treating these social media apps like products. Think of any product liability case like the tobacco industry. The core allegations are that these companies engaged in a known risk. They created these very addictive algorithms that they knew would impact mental health. They failed to warn users, specifically minors, about those impacts and put up guardrails to safeguard the user. So that's the legal theory here. And this is really the tester case. There's thousands of others behind it. It's really going to set the tone for how those play out.
As you lay it out, Misty, it sounds convincing, but these companies are pointing to one federal law, they say, shields them from these kinds of lawsuits. Take us through what that law says and how strong that legal argument, that defense rather, would be.
Yeah, so this is the tricky part for the plaintiffs in this case, because it's going to come down to the issue of causation. Did the actual algorithm, this addictive nature of these apps, actually cause the mental harm? Or is it the content that the user is viewing that creates the mental distress? If it's the content, they're protected by a federal law, 230 of the Communications Transparency Act, which says that these platforms cannot be held liable for third-party content, which would also be protected by the First Amendment. So if the causation, if the jury were to conclude that it's because of what the individual was viewing, then that would really shield these companies from liability. Whereas on the other hand, if they think that there's intentional acts on the part of the companies to create these addictive algorithms knowing that there is the risk of harm, different story.
Can we pick up there, though? If that latter case is in fact proven to be true and they are found guilty, the companies themselves, how would that actually impact the app itself?
So if they're found liable, there's all these other cases that are coming around the bend. Again, thousands, multi-jurisdictional. You're likely to see this go up on appeal. If it is upheld against these companies, you're likely to see a lot of settlements across the board and major changes in the way that these apps function, whether it be additional guardrails, safeguards, changes in the technology. It would really change the whole landscape, not just the legal landscape, but also the way that these apps are actually implemented. So major changes.
Quickly before you go, Misty, tell us who's bringing the case. Who are the plaintiffs?
So these are the first ones are minor plaintiffs who are bringing the case against four social media companies, although TikTok and Snapchat settled on the courtroom steps. So they're out of the case right now. It's Meta and Google, YouTube, and Facebook. And Mark Zuckerberg is slotted to take the stand.
All right, Misty Maris, come back and tell us more.
Absolutely.
We thank you for watching, and remember, stay updated on breaking news and top stories on the NBC News app or watch live on our YouTube channel.